My name is Debbie Reynolds. They call me the Data Diva. Today I want to talk about data privacy, Google, and Android. Currently, there is a case that Max Schrems, who's the activist lawyer from Austria, has filed in France related to the use of the AAID, which is similar to Apple's device ID used for advertising. So the gist of the case that Max Schrems filed in France relates to the use of cookies. So he's filing it using the ePrivacy directive in the EU. Also, the big issue is that he claims that whenever someone uses an Android device, they can't really consent or really opt out in the way that the directive calls for in terms of advertising. So there's a similar case that Max Schrems filed against Apple almost for the same thing in Italy, I believe, related to kind of the consent mechanism and how people can opt out of advertising. This is a case that people are going to look at really closely. As we see, Google and Apple are making changes to how they share third-party data with advertisers, and especially Google, because a lot of their the money that they make is on advertising. It's going to be very interesting because even though Google has made changes like creating this flock apparatus where they're trying to give marketers less granular information about the identity of an individual and sort of put them into groupings based on their weekly search history. I think the fact that their basic business model hasn't changed, they still sell advertising, will be something that comes up in this case. As we've seen, Max Schrems has been very successful in getting quite a few things internationally invalidated. Most recently, in the most recent years, that would be the Safe Harbor framework, and also I always forget, the data privacy sharing framework between the EU and the US. And also, even though he wasn't involved with it, the Swiss and US Privacy Shield, as a result of the Privacy Shield invalidation between the EU and the US being invalidated, Switzerland decided to invalidate their Privacy Shield. So I think this will all tie in some way to Privacy Shield and really inform how these different countries tackle this issue of how advertisers use information that they obtain on individuals, and if the types of consent are proper or are legal based on not only EU law but also other regulations around the world that are targeting this kind of data sharing and how marketing happens with individuals. So it remains to be seen what will happen with this case. These cases go on for many years, so we'll probably be looking for a couple years to see how this plays out. In the meantime, I think a lot of companies are trying to shy away from using cookies in the ways that they have been used in terms of being able to gather information about people without their consent. Obviously, cookies are not going to go away. They'll probably go back to their original purpose, which was to help save settings in the way that people browse the internet. So, for example, let's say there's a website that you like to browse in dark mode or something. If a website has that feature, they may put a cookie on your computer so that next time you go there, it'll remember that setting. That's kind of the original purpose for cookies. But we know now that advertisers have found creative ways to go above and beyond those types of things, and those are the types of things these regulations are trying to tackle, which are data gathering about individuals without their consent or knowledge. That's it. Thank you.